Hello and welcome to Answer the Question. Today, we're going to be talking about the judicial branch and how it's structured. As I said in the branches of the government video, most of our federal court system is created by Article 3 of the Constitution, which establishes the Supreme Court and then lets Congress establish inferior courts under that court. And over time, that has led to the three-tier system we see today in the federal courts. At the top is the Supreme Court, which has the final say on any question of law which is under federal jurisdiction nationwide. Below that are the federal circuit courts, also known as the U.S. Courts of Appeal. And there are 13 of these circuits. There are 11 numbered ones, which cover different geographies, which you can see on screen, plus the D.C. Circuit, and lastly, the Federal Circuit, which handles certain special types of cases. And at the lowest tier of the Article 3 courts is the federal district courts, of which there are 94, and there's at least one in each state. These courts are actually the only federal courts with juries on them. Every other court is decided only by judges. In addition to the Article 3 courts, there are also Article 1 courts, which are established by Congress to focus on specific types of cases. These courts, along with the federal district courts, are collectively known as the federal trial courts. That means that a case, outside of very special circumstances, has to go through them first. The way that these courts work together is that the trial court will make the first decision. And if one side believes that there's a mistake in law, then they can appeal to the relevant circuit court. These circuit courts will then look at the rule of law aspect and make a decision that the trial court has to follow. But those circuits do not need to make the same decision. Different circuits can have different rules for how to interpret a specific question of law, which is called a circuit split. The only way to resolve one of these circuit splits is to appeal it up to the Supreme Court, which happens through a special process known as the writ of certiorari. Once a writ of certiorari is filed, it is up to the Supreme Court to accept that writ, which is actually pretty rare. The Supreme Court chooses all the cases that it hears, and it hears about 80 with oral arguments and about 100 without oral arguments every single year, which is about 3% of the total cases that are petitioned to the Supreme Court with a writ. Leading to the situation we have now, where we have 88 major circuit splits across a wide range of issues. The last part of the judicial branch involves the administrative agencies of the judicial branch. And those agencies are these. The most important of which is the Judicial Conference, which creates and revises the federal procedural rules for the courts. That's all for this one. Next time, we'll be covering the executive branch, the one you've probably been waiting for. So I'll see you then.